Hey, good people. Before we start this podcast, I wanted to let you know a little something. If you haven't heard about Anchor, it's the easiest way to make a podcast. Let me explain. First of all, it's free. And not only that, there are all these creation tools that allow you to record and edit your podcast right from your phone or your computer, just like I did. Anchor will also distribute your podcast for you so it can be heard on Spotify, Apple Podcasts, and many other platforms. You can even make money from your podcast with minimum listenership. It is everything you need to make a podcast in one place. So what do you need to do now? Download the free Anchor app or go to anchor.fm to get started. Hello, good people, and welcome back to another episode of Real Talk and Real Estate with your girl, Kim McBride, also known as Get Keys with Kim. I didn't want to say it, but I'm going to say it. I am more than over the moon for our next guest because this topic is one that is near and dear to my heart. I think it is so important. It reaches and surpasses all barriers of race, color, creed, economic status. Like, it is so important what we're getting ready to talk about today. And who will be joining us is Mr. Erick R. Tyrone, Esquire, who is the founding partner of the Tyrone Law Group, LLC. So let me tell you a little bit about him. Erick is the founder and principal attorney of the Tyrone Law Group, LLC, an estate planning and personal injury law firm based out of Largo, Maryland, servicing Maryland and the District of Columbia and Virginia, affectionately known as the DMV, through of-counsel relationships. Before founding his firm, Erick worked as a contractor with the U.S. Attorney's Office in Baltimore, investigating Medicare and Medicaid fraud. While working with the USAO, Erick developed an interest in educating the citizens of Maryland about the importance of estate planning and educating the members of his community about the process of building and maintaining generational wealth. Erick is a licensed sports agent for the National Football League, and in his spare time, Erick serves as an assistant football coach at a local Prince George's County high school. Erick is also actively involved in community service through his fraternity, Omega Psi Phi Fraternity Incorporated, and Erick is a graduate of Columbia University in New York City and the University of Wisconsin School of Law. Not to mention, he is the proud son of an Air Force veteran. Everyone, please help me welcome Mr. Erick Tyrone. Erick, thank you for joining us.
How about yourself?
How are you? I'm great. So I done put a lot of juice into this, so this is going to be a good one. I've hyped you up because I know that you can back up everything that I'm saying. You know, we've been following each other for a little while on Instagram and social media, and I've seen the good work that you've done in the communities, and even an event that I would love for you to discuss before this podcast is even over, or future events that you're having, so that others can benefit from what you do and what we're going to talk about, which is estate planning. So before we begin, tell us how you got into this field. Why estate planning? Why personal injury? What was it about those two specific types of law that drew you to them?
Me, it was about the beginning and the end. The beginning is the estate planning because, you know, in this business, when you're opening your own firm, you have to be able to drum up some business, so to speak, right? Personal injury cases sometimes take, years to be resolved. And so if I thought, hey, look, I got to be able to cover my expenses on the first of the month, I'm going to have some way to drum up some business to be able to actually, cover, the life, because, you have employees and staff and, they want to be paid on the 1st and the 15th.
Right. That's right. That's honest, but that's legitimate.
Yeah. And the personal injury is kind of the long-term game. Get out of this so you don't have to work, you can work smarter instead of harder. Because, ultimately sometimes you can find the right case that can, put 7 to 8 figures in your pocket at one time, then you can find a way out of the rat race. So that was kind of the genesis of both of those.
Absolutely. Awesome. And I think even for you, even though you're talking about business strategy, I think that easily can correlate to those of us who may not be in the field of law, because what I know a lot of my clients don't understand, and a lot of individuals who purchase property don't realize, is that purchasing a home is a business transaction, and you have to protect that asset. And in order to do so, it's important to have things put in place before you die, even after you die, so that those things are clear, so that those assets, this home, what it should be given to maybe children or a spouse or to heirs, can be protected. So I know one of the things that I suggest to my clients is to get a will. It's the first thing I suggest. There's a few things, but that's the first thing. So can you talk a little bit about how the will process works?
Well, I encourage someone to go reach out to an attorney that understands how to draft wills, understands what the requirements are from a perspective of what the judge is going to be looking for when reading the will, so that the requirements that are necessary in order to enforce the will are met. Right? I mean, it's one thing anybody can go online and find something and start drafting it and using that document as if it's going to be sufficient to serve as their will. I mean, you can grab a napkin and start writing on that, but that doesn't necessarily mean it's going to be sufficient. And there's reasons why we go to law school and try to learn these areas of law to be able to practice and maintain and make sure that we're protecting somebody's interests properly. So I encourage you to go to somebody. If you don't go to somebody, then just understand that you're taking the risk of your documents not being enforceable. And I think the only way that anybody's ever going to learn whether it's enforceable or not is when it's too late. So you can, it's something you can do yourself. If you don't have training, I don't think you should. But people come to me all the time and say, hey, look, I got something on LegalZoom, or Staples or something like that. And is this good enough? And to me, I think that's just it's the example I use when I teach is, if you went to Staples and they said that they've got a $40 kit that's going to teach you how to do a hip replacement, would you go buy that hip replacement kit and go home and go do it yourself? Of course not. So I encourage people to go make sure they get a professional to be able to help them out with serious projects.
Gotcha. So I'm a worst case scenario kind of girl. So let's just say hypothetically, someone does get a kit. They go online or they print something out. They pay their $20, $120, however much it is. And it turns out that whatever they've created will not suffice, will not stand in a court of law. What then could potentially happen?
You're going to probably end up, if it's not enforceable, dealing with the rules as if you did not create a will. Okay. So either you have a valid will or you don't.
Okay.
And so in the instance where you've created a document that purports to be a will, but it's not valid, then basically you haven't done anything, and you've basically gone back to the rules, the default state rules that decide how do you pass your assets to your heirs. And so, for some families that's sufficient, but certainly not for everybody, because I mean, clearly there are mixed families, there are blended families. There's just so many different, there are people that, Big Mama's been taking care of Uncle Lester for so long. And, of course that's not her real child, but that happens, especially in our community. And, in the end, if you don't want Uncle Lester to be able to stay in that house, you want to be able to take care of the assets and do what you want to do and take the control that you want to have.
Understood. So can you, even though this podcast is for anyone, anywhere, can you take a moment to speak specifically for the state of Maryland? So how does that work in Maryland if it's interstate, if you do not have a will?
So if you don't have a will, then you have basically said that the spouse, if any, is entitled to, right now, the rules are the spouse is entitled to a third of the remaining assets after you get what is called a family allowance. So once those assets, let's just assume we have one house, okay? And in Prince George's County, or in Maryland, and a lot of these houses can easily be worth $400,000. So that's an easy. All right, you got a $400,000 house, and prayerfully, it's already been paid in full, and so you own that asset. And just for for giggles, let's say that the house is completely empty, but it's $400,000 house. Well, at some point you say, all right, if I pass, I want that house to sell, and then I want to disseminate those assets to my wife and 2 children. So if I leave a wife and 2 children, I've left what they call 3 issue, ISSUE. All right, they consider everybody you leave as somebody as an issue. Okay, and so everybody, a lot of different states, a lot of different jurisdictions handle it differently. Some people say the wife gets half and the kids split the other half. Some people have the wife gets a half and then she also shares with the children in the other half. Well, the Maryland wife gets a third. Okay, so after the spousal allowances, the wife gets third, and the children split the rest. So we're talking about $133,000 that's going to the wife, and the children would split the other $133,000 apiece. Now, in this particular instance, we have to talk about, are the children adults? Are they old enough to receive assets from the parent? Because if they're minors, you can't give a minor $133,000 through the court. They're going to have to deal with some type of guardianship proceeding where you put those funds in trust somewhere in a bank account, so that, and they have to report back to the judge and make sure that the judge knows, all right, these assets haven't gone anywhere, they're here, and you report back to the judge annually about those assets.
Okay. You've said a lot there. I have a million questions now. Okay. So let's jump back to the scenario with the house. Let's assume that the house is not paid in full. Let's say that the person that is now deceased was the person on the loan. How then does that work for the mom or the spouse and these children? And these 2 children, so the 3 issues. How does that work for
still
them?
A mortgage on the home. And let me just clarify, when you say the wife is not on the note at all, she's not at all listed, or she's listed as a co-borrower? Not at all listed. Okay, so you want to make this
not at all listed.
All right. So if she's not at all listed, then she's going to have to reach out to the bank to say, if she wants to assume the mortgage, maybe she's got a good job as well. She's, if she also has a good job and she can afford to purchase this house and maintain the note that they currently have, then she could technically refinance or assume the loan that they currently have and just keep making the payments. Sometimes when it gets into like when we go to Big Mama's house, somebody's been living in Big Mama's house, they just keep paying the mortgage. They don't really tell the mortgage company that somebody's passed. So sometimes the banks will allow you to do that for a period of time, but eventually they know that they have a secured interest and that it'll all get sorted out later on. So in the instance where there is an outstanding mortgage, if you want to keep the house, then you need to talk to the bank and be able to either refinance or assume the mortgage, and basically show yourself credit worthy to assume the current mortgage that they have and just replace the previous person and just keep making the same payments. Or if we're going to be in the position where we're going to sell the house, well, you're going to sell the house, but now you're going to have to pay off the outstanding mortgage, right? So we said we had a $400,000 house. If there's $100,000 worth of a mortgage left, when you start, after the sale, and now you've got $300,000 left. So now technically everybody's entitled to $1,000, assuming there are no other creditors
Mm-hmm. So does the spouse then have the right to sell the house? So the wife is not on the mortgage, but she cannot
Okay.
refinance and she cannot assume it.
Well, she's
Does she
not
then get the
immediately.
right
Okay.
to
The
sell
first
it?
thing that she's going to do is she's going to have to assume the authority. She's going to have to gain the authority in order to do anything. And she gains that authority through the probate process, right? I know a lot of people have heard of the term probate, but not everybody understands what exactly it means. All right. So probate process is the process, the open process where you go and you um, the process is designed to transfer assets from one generation to the next. Okay. And so in this instance, when, I passed away and I'm trying to transfer my assets to my wife and kids, and they want to be able to live and maintain in my own home. But since I am the signator while I was alive, I have the authority to sign for myself. Right. As long as I've got my own mental capacity,
Mm-hmm.
I can sign for myself because I have that authority. And we've all done this. We've all gone to sign some contract, and we have the authority to do that. But once I die, I no longer get to sign for
Mm-hmm.
myself. And now I'm dealing with a secured note, a secured contract with a bank where I'm supposed to pay this monthly fee to this bank until I've paid it off plus the interest. And my wife is not a party to that contract. She might be a beneficiary of this contract because she lives in the house, but she's not a party to that contract. So she has to get some type of authority. The bank will not even talk to her about this because until she gets the appropriate authority from the court. Okay, so what has to happen is I got to start a probate process with the court. I got to start this by filing a petition with the court to say, Your Honor, here is a financial snapshot of what Erick looked like when he died. Right. And you say, basically, at his time of death, I think we're all old enough to remember those Polaroid cameras where you take a picture and out pops this little
Mm-hmm. Mm-hmm.
film, and you start shaking it and blowing on it to make sure that
The film.
it starts to fill out. And when after a few seconds, you start to see the picture and it starts to depict what somebody is. That's a snapshot of whatever that Polaroid was looking at directly in front of it. Well, you're going to do the same thing to a judge. You're going to take a financial snapshot and say, Judge, at the time of death, Erick owned one house. He had one car. He had, two bank accounts, and, he has wife, two children, and, this will here. Right. And, the reason why we have to present all this in front of the judge is the judge first has got to figure out, all right, what rules are we dealing with? Are we dealing with the rules that he has written down on his will, or are we dealing with the rules of the state for the default rules if somebody dies without creating a will? And so we have to present all of this in front of the judge, and then the judge will
Okay.
ultimately appoint somebody as the personal representative, the person that's responsible for making decisions, the person that has the authority to sign for the dead person's signature. And that's what, once they have that authority from the court as the personal representative or the executor or the administrator, they got a whole bunch of different names for it, but it's the same thing. Once you have that responsibility, then you have the ability to sign for the dead person's assets.
So is probate a good thing or a bad thing? I've always thought of it to be negative.
I think most people think
Would you
about it
say
as
that
negative.
it's
I think most people think about it as negative because it's so time consuming, it takes so long to do, and it's so expensive, and it's so stressful, right? So the idea is, everybody, whether you have a will or whether you do not have a will, you have to go to probate. And the only way to avoid probate is to have a trust or some trust-like structure. Okay, where we're saying you got a revocable, irrevocable living trust, you have a foundation, or you have some other way that you have your assets tied up such that you don't actually own those assets. Your trust does. I know that's a mouthful, but
Okay, this is
but I'm
good.
trying to put it into bite-sized pieces.
Oh no, I'm taking notes so I can keep up with this. Okay. So with probate, it can be lengthy. What would you consider
Well, let's start with
lengthy
it's
to
going to be
be?
at least a year. Okay. If let's say, I'm Eric, and
Okay.
if I died on February 1st of this year, 2020, you can promise that you're probably going to deal with this, in the same scenario that I just mentioned. I had one house, one car, two bank accounts, one wife, two kids, and a will. That's the simple estate. Those are the easy ones. The easy ones are going to take at least a year to get resolved, to sell that house, to transfer these assets, yeah, I mean, that's just, I'm not saying it can't happen faster than that, because I'm sure it possibly could, but for the most part, it's going to take at least a year to get resolved. And then, the ones that have real complications, let's say my wife had two children outside of, she was married before and from a previous marriage, and now we've got two children that are hers, two children that are mine. I may have adopted one of those children because the other one was old enough. I mean, you can just think about how many scenarios that could come in. It's impossible to show all the derivatives of that, but once it starts getting sticky, it is easy to get sticky, and take a long time.
Yeah, I think we need to have you as a marriage counselor. You need to be partnered with a marriage counselor, because
No,
I know they don't talk about this in counseling, because this is some intense stuff. Like when you're thinking about, you know, the frou-frou-la of getting married, the wedding and all of that. Like, I'm certain most people are not thinking about protecting assets and death, and you're not thinking about the
right.
end game, so to speak, at the start of a new life. So, okay, what takes it so long, Eric? Why
Well,
a
there's a couple
minimum of a
reasons.
year?
One, there is a 6-month period where it's a waiting period where we have to wait for the creditors to file their claims, right? So that means if you've got a Macy's account, if you got a Discover card account, a Bank of America credit card, whoever, they have 6 months to file their claim from when my wife gets appointed as the personal representative. So even if you choose to sell off all the other property, right? You got one house, that's fine. My wife doesn't want to live in that house. She didn't like it anyway. She's taking her and the kids. They're going back down south, going to live in Big Mama's house, and they don't care. They hire Kim. She sells the property real fast because that's what she does. And now those funds have been put into a bank account. They're set aside. The car, they took it back down to Big Mama's house. They had, two bank accounts. They put all that money in the same account, and they're done. The reality is that person at that point, now you have to go and start filing accountings and make sure that you process, you know, get recompensed, get reimbursed for funeral expenses, and paying the taxes on the house for one of those tax payments got made, and you want to get reimbursed for those assets. You want to get reimbursed for the assets, or the money that you spent actually filing the petition for the probate and filing the newspaper fees that you have to do when you file this. And there's 100 different things. And of course, Kim, you came in and you fixed up the place, and so you made you instructed the wife to come in and make sure you keep the lawn cut. So we had to pay a lawn guy to come in and paint the lawn, to cut the lawn and paint the walls in the house to make sure there was a nice sheen. And you might even cleaned out one of the rooms because it was just messy, so you had to pay for somebody to come in and clean that place out. And just a little bit of decorative furniture you rented. And so, right, all these different expenses, we got to start adding all these up and tallying these up. And the reality is, it sounds extra simple. Oh, just keep track of the receipts and tally it up. But in real life, that just takes time because you're busy, you're handling life. And, by the time you get it done, you look up and it's a month later. And now, you're starting to tally this up, and, maybe you lost one of the receipts, and you got to go call the painter, hey, I don't see the invoice that you sent me, and this, that, and the other. And of course, is he going to get right back to you? No, it's going to take 2 weeks for him to send something back to you. And so, sure enough, before you know it, you've already spent 6 or 7 months, and now you're at a year. That's how it happens. It just happens so fast.
Facts. Okay. So you brought up some really interesting points that I wanted to touch on. When it comes to the probate process, well, you mentioned like paying for things like the funeral expenses and things like that. If this money or this whatever the assets are is tied up in probate, that means that the surviving spouse or heirs are then responsible for paying those debts in the meantime before
No,
the money can be
that's a
released.
really good point. They're not. It's not
Okay.
going to be incumbent on them. Erick Tyrone is the one that died. Erick Tyrone is the one that had the Discover card. Erick Tyrone is the one that has to pay for the Discover card, and you pay for it out of Erick Tyrone's assets. So if Erick Tyrone owns a home and owns a bank account
Mhm.
and owns life insurance and this, that, and the other, then Erick Tyrone may have some assets to pay for that Discover card. Okay, but if he didn't, then he wouldn't have the ability. And that does not mean that his wife is responsible for his debts that are in his name alone. Now, if her name is also on those debts, that's different. But in anything that's got his name alone, he's not responsible for paying. And I can't tell you how many of my clients have gone in, well, this was, mom had an estate. They come to me afterwards and they say, hey, um, you know, when my mother passed, I had to pay, you know, $12,000 because she had this, that, and the other bill. I says, what? You didn't have to pay that. That was not your responsibility. That was your mother's responsibility. And if
Mhm.
her estate did not have the assets, her financial snapshot, that Polaroid that she took, that we handed to the judge, if that did not have the assets to cover those bills, then no, she did not have to pay that. Does that make sense?
Wow, it does. This is
I
where
agree.
folks need to hire professionals because we think we know what we're doing. I find it often in real estate as well. Folks are like, oh, no, I can't do that. Let me pay off these bills real quick before I get a mortgage. And then it ends up
Mhm.
backfiring on them. So this is why I have you here today
Mhm.
because we need this information. Okay. You mentioned that
Yes.
probate can be expensive. What would you consider expensive? What are we looking
I
at
would
here
start
for
at a cheap
probate
one is
fees?
about $7,000 to $10,000, right? I mean, that's really cheap. That's run of the mill. There's very little to do because when you talk about the amount of time spent processing, in a state, I think that's a really cheap. I think I'm now in Maryland. When I start quoting people, I start at about $15,000 for most of these. If we start in DC, it's probably going to start closer to $20,000 because DC has just a little bit more red tape on some of these estates. And that doesn't mean that everyone is going to be there, but I'm saying that's if I just ballpark it for people, because people want to get it straight. They want it
Okay.
straight with no chaser. All right, if we're gonna straight for no chaser, the ballpark is gonna let's start here. If there's money left, you of course you get it back. But if not, it could easily go higher than that.
Understood. So, do these funds for probate come out of the deceased
Well, not
assets?
always. They
Can
can,
that be
right?
brought?
They can, and each
Okay.
attorney is going to be able to work with somebody differently, right? If I am concerned that a wife comes into my office and says, hey, look, we don't have any cash right now, but we do have this house and we're ready to sell this house. And Kim is our realtor and I know she's going to get it sold. Perfect. Then maybe that gives me the ability to say, okay, I may not need as much from you up front because I now can work with Kim to ensure that I will get, my attorney's fees covered when that house sells. But now that goes and says, now you have to say, all right, but now that cuts into what we're disseminating back to wife and kids. Understand that there is an expense. and to get that kind of help to be able to process this, because this is a stressful process. It can be very stressful for
Absolutely.
somebody, especially as they're trying to mourn. They're trying to continue to raise kids. They have to move now. They got to, in the scenario we're doing, somebody's moving, and you're doing all kinds of stuff, and we haven't even started talking about their own mental health and trying to get, their life back together, from somebody from a close relative that passes, and who needs and who wants to have to deal with going back and forth to the court talking about money, especially in the situation where, in this case, it's all staying in the family, right? But it still doesn't stop us from having to go through the same process to be able to make sure that these assets actually get properly taken care of. We're not even going to go into the situation where we've got brothers and sisters fighting and they can't agree on who does what, and because those can get even, that adds a whole nother layer of stress.
Absolutely. And we've seen that all play out on TV and sometimes in our own families as well. And I know that not having a will in place or not having certain protections in place can be more costly than what it would be to hire an attorney. But for those who feel like, listen, I can't afford 7,000, let alone 15, let alone 20, what would you suggest? Are there anything or any products or services? I'm just trying to think, is there like insurance? Is there something that can be put in place to help kind of alleviate that for those who may feel like, even though it's well served, able to pay this fee and protect these assets
Well, yeah.
without
So I mean,
doing it themselves, and
I
then
think
maybe
one
the
way
cost
is you can, if you had your assets in a trust, you wouldn't have to worry about the probate process at all. Okay, that's one way. If you had life insurance proceeds, those could be used to take care of the funeral expenses and could be used to pay for attorney's fees in order to process the probate. So there are certainly ways, of saving up and using investments to cover these different expenses. And so the idea is, if you can, but we've all heard the phrase, an ounce of prevention is worth a pound of cure. Well, that's because it's basically saying that it takes 10 times less energy to attempt to protect something before you have to fix it, right? So the idea is, if you have to fix a problem, it's going to take a lot more time, energy, and money than it does to just do it right the first time. And so that would be my encouragement about dealing with will-based planning versus trust-based planning, so that you can actually start planning ahead of time to make sure that you're protecting your assets and what's right for you, because it's not a one size fits all. It's not, everybody doesn't fit into the same basket, and saying that everybody should do the exact same thing.
Got it. Okay. I want to get into trust, but before we do, I wanted to ask a final question regarding the scenario we have. So we previously talked about the husband passing away and then the wife not being on the mortgage, which then led to the financing or assuming the mortgage and then selling the house, which led to the probate. However, what if the wife or the surviving spouse is on the deed? So they're not on the mortgage, but they're on the deed. Does it still then go to probate? Because then she would have the right to sell because she is
well, again,
owner based
remember,
on the deed.
Anybody, if you have a will or you do not have a will, you are going to go to probate. So they're not gonna avoid it just because she's on the deed. All they've done is, by putting her on the deed, is making sure that she has an ownership interest in the property in actuality, as opposed to just as a survivor of the spouse. Okay, so she had an ownership interest in the property before he died, because she has a survivor's interest being married to somebody that she's going to have that role. But whether he had a will or not, that doesn't determine whether they're going to have to they're actually going to have to sell, or whether they're going to have to go to probate. That probate is already designed. If I'm dealing with will-based planning, which means you have a will or you don't have a will, you're going to go into probate if you own real property. And so the deed is separate from the note, which means the ownership, the title and ownership is different from the responsibility to pay for the ownership, right? It's like your dad buys you a car. Okay, if dad bought me a car, he used his payment to his credit to purchase the vehicle. He's the one that's got the note. He's the one that has the responsibility to pay for the vehicle, but he might have put it in your name. And so you also have it, it's in your name. That's the exact same situation. We're talking about that. The fact that you have something in your own name as entitled doesn't necessarily prevent you from having, or it doesn't have anything to do with the responsibility to pay for that ownership interest.
Got it. Okay.
Mm-hmm.
So now getting into trust. How do trusts work? Especially when we're dealing with, or if it even makes a difference when we're dealing with children. Does it make a difference, one trust for children versus one trust period for the estate?
Well, that is let me back up a lot in order to be able to answer that question. Okay. So let's talk about what is a trust. Okay. A trust is a binder. It's a binder full of documents. Okay. And this binder full of documents tells you what it is you want to do, right? So for example, if I go to Home Depot and I buy a Build-A-Box, it's literally just a bunch of wood, some screws, and a set of instructions that tell me how to put this box together, right? So in the end, after I'm done, hopefully I've got wood, I've got a bunch of screws in the wood, and I don't have a whole bag full of screws that are left over, right? And I've got this wood, I've got this box, and I've got this set of instructions. If I don't put any assets, if I don't put anything inside that box, all I've bought is a box of wood, a set of instructions, and a bag of screws. So a trust is similar. A trust is a document that has a set of rules that teaches you what happens to my financial box. Okay. And so a trust isn't just one document. It's going to come with supporting documents, certificates of trust, affidavits of trust. It's going to come with personal property memorandum, healthcare directives, wills, pour over will, and powers of attorney, et cetera. There's a whole bunch of different documents that are going to go in this binder, right? But this binder tells you that when it boils down to it, somebody is going to be the trustee, the person that's responsible for making the decisions. The person has access to the assets that are inside that box. Okay. So again, if I don't put any of my assets inside the box, all I've purchased is a big, nice, expensive binder with a whole bunch of pretty paper. It doesn't mean I haven't actually done anything. So my job, once creating the trust, is one thing. Actually funding the trust and actually putting your assets inside the trust is another. So for example, you just talked about a deed where husband and wife were on a deed. Well, if the husband and wife die with their names on the deed, even though they had a trust, they're not going to avoid the probate process. Why? Well, when they died, they themselves personally owned that house. The trust did not own the house. We did not put that house in that trust. We have to change that deed and transfer that interest from those individuals, husband and wife, into the trust or trusts that the husband and wife create. Does that make sense?
It does. Oh, this is getting complicated. Not complicated, but there's so many there's so many twists and turns with, like, there truly is no straight path to this. There's no cookie cutter.
Right.
There's no I can give you one answer.
Situation is different.
Especially when we're speaking about Yes, there, and I feel like
Oh, yeah.
really, Eric, we may have to do a part two because
Yeah, we're just scratching the
there's just
surface
so
right
much
now. We're
with this,
just scratching the
you know.
surface, and I'm trying to make it in bite-sized, digestible forms for, your listeners, for yourself, because I want you to be able to understand it and to be able to teach it. In the end, I want, the I begin and end my seminars with informing people about what is a proper estate plan, what is proper estate planning, because that's different for everybody. And I wish it was as simple. I think lay people, everybody wants me to say, oh, if you have a will, you have a proper estate plan. Well, no, I don't actually agree with that. I agree with the what is a proper estate plan for everybody varies. Some people need a will, some people need a trust, some people need more than that. But the way to determine what a proper estate plan is did you solve the problem? Right? And the problem is I want to be able to give what I want. It's a 5-part test. I want to give number 1, what I want. Number 2, to who I want. Number 3, when I want. Number 4, how I want. And number 5, I want to be able to say that if I'm unavailable to make my own personal financial decisions or healthcare decisions, I want to be able to appoint who's going to make those decisions for me. Okay, so I'll try that again. It's a 5-part test to determine who has a proper estate plan. And I think your estate plan would be determined proper if you can solve this 5-part test. Number 1, I want to give what I want, to who I want, when I want, how I want, and then I want to be able to decide if I'm unavailable to make my own decisions for myself, whether it's financial or for my health. I want to be able to appoint the person that actually makes those decisions for me. So in that scenario, if we're talking about me transferring my assets to my family, my heirs, or whoever I want, that really boils it down. That really says, hey, look, this is case specific. I can't just go with a cookie cutter approach and say that everybody's going to want the same thing, because that same will is not sufficient. We already talked a little bit earlier about we sold this house, we have $300,000 left. A wife gets a third, and the kids they split. Those 2 kids split the other third, and so now everybody gets $100,000, but the kids are 7 and 8. And you can't give a 7-year-old $100,000. And even if you could, who the heck would want to, right? So the idea is, even if I had a will, a will does not necessarily protect me in the same manner when I've got a 7 and an 8-year-old here with a house. I want to be able to have some semblance of control to be able to say what happens for the kids' portion. I want to be able to say, all right, I want the kids to go to college. If they go to college and do this, that, and the other, and they get good grades, then they can get a portion of this. Because a whole bunch of us, just because you reach the age of 18, doesn't mean that we're responsible enough to be able to handle $100,000 cash and actually be able to have something to show for it in 2 years.
Right. Okay. So how about we do this? So I have
Sure.
a few more questions about trust, and then we'll definitely have to, maybe when your schedule permits, set something up to talk about some of the other
Yeah.
layers, because there's so much more I wanted to ask you, but it would take us literally
Easily.
another hour and a half
Easily. I
probably to get
appreciate it.
through it. You're doing a great job. For someone who is not as familiar with this, I mean, I feel bad now. I'm like, I tell everybody, get a will, get a will. Now I feel like I need to go back and tell all those folks, wait a minute, let me give you Erick's number
Right. I
real
think
quick, because I think I might
I
be
think
able
they
to
should
guide you
just
on
come
this part.
to one of the
So,
seminars that I do. And recently I've started doing monthly seminars where I literally talk about estate planning, talk about what does proper estate planning mean, talk about the pitfalls, the joys, the pains, the dirty, the dirty details. And I spent about 2 hours at my office, and I just go over this. And this is something where, I do it, like I said, once a month. This year, or this month in February, it's going to be on the 29th. Next month in March, it's going to be on the 14th. So that's going to be on a Saturday in my office. You come in, it takes about 2 hours. I have light refreshments, and then you can start talking about this. You can start hearing, this information, and ask and answer questions, because the reality is it's too much just to go over a short, quick phone call. I think you should come and understand what's going to happen, understand what the picture is, what it looks like, and and how your particular situation falls within this picture. I think that's the point. I want people to be able to walk away feeling a bit more informed about what their options are and what's going to happen if they do nothing, because maybe doing nothing is the appropriate plan for them.
That was you put that really nicely. I don't see how that is a plan at
Well,
all, but
think
okay,
about it
I'm
like
with
this.
you.
All
I
right,
am
let's
with you.
think about it
I'm
like
picking
this.
up what you're
Okay,
putting down.
you've got a mother has her husband predeceased her. She had one child. She actually currently lives with that one child in the mother's home, and the mother and that child, is 45, 50. The mother's 75, 80, and the child is taking care of mom and bringing in some help to be able to take care of her assets. The mother has already added that child to her bank accounts, so she's already got that taken care of, and that house is the major deal. Now, it's a DC property, so let's say it's in Northwest, and we know how people are eating up those properties in Northwest. So there's only one person that has the asset. It's going down to one person. And so if mother dies, there's only one person for it to go to. It's possible that the scenario that she was going to write in her will is the exact same thing that would occur if she did nothing, because her assets are going to go to her daughter. Now, the fact that she has to deal with probate is, as opposed to being the successor trustee, that's a little bit different. So if she had a trust, that'd be one thing. But in the end, does mother want to pay the amount of money to create a trust, knowing that her assets are going to go directly to her daughter anyway? Well, she may say, in the short term, I don't want to spend, let's just throw out a ballpark, $4,000 to $6,000 creating and funding that trust. I'd rather go and just allow for when my daughter sells that house to be able to, pay for those proceeds out of the sale of the home. Well, that's her wish. That could make sense.
Okay, I never thought of it in that way,
That's a possibility.
so I could see it.
There is a scenario.
Just based off the conversation we've had, I need to get me a trust now. Now I've been doing this thing wrong. So if I can ask you these few questions, and then what we'll do is we'll wrap up this segment and do a part 2, because we have to, because this is good. So you mentioned earlier a few things about a trust. The first thing was about, we'll use our scenario, husband, wife, and 2 children, knowing that families can be of any makeup, right? But just using the husband, wife, and 2 children. Husband passes away. There you have the 3 issues. Each wife will assume it's a third goes to the other 2 children. Assuming they are minors and it needs to go into a trust, or it has gone into a trust. You mentioned about having a report done to the court. Is that until the child turns 18? Or is there some other requirement or precursor to that?
Okay, so your phone broke up just a little bit on the last question. Can you say that again?
So no problem. So with surviving children who are minors, if their assets then go into a trust, and the guardian then has to give an account for how the money is spent in the trust, is that done up until the children reach the age of 18, or is there some other requirement? of age in which there no longer needs to be a reporting of how that money is being
they're going to
used?
go in. There's going to be a formal guardianship action that you have to file. You're going to have to file a petition with the court to serve as the guardian and put those assets in an account. I chose to call it a trust, but until it actually is named that,
Okay.
it's just by putting it in an account, such that you're going to have to report those assets that are in that particular account to the judge through the guardianship process. And that's even if it was somebody's direct spouse. They're the mother of those children. Now, she'd probably be the person that would serve as that guardian, but she is not. She's going to be responsible. She has to give those assets to those children. And so the scenario where this is most apparent and most dangerous, I say dangerous because imagine this same family and the parents just had not gotten married. So you've got father and mother and two children. They're living together, they're buying real property together, they're titling it together, all that. But they are not married. And so now when father passes, I guess in the second hour we'll let mother be the one that dies off. But in this hour we'll let father die off. And so when father passes, now he's attempting to transfer his assets to his children. And now this is, there's a difference. If they're not married, you could present a different issue for, for those kids, especially if she's not the mother of those children, right? Because they could just be dating. She's been taking care of the children and she's not the mother of them. So now you actually have another mother that's out there. And now who has the right to actually disseminate these assets? Who has the right to the assets? And then who has the right to control the assets in the guardianship proceeding when we're taking care of those minor children? So you just pose so many different problems, and you pose all these different problems just because of, we not having these things in a trust. And I have to present this to a probate court that has a set of rules that we have to abide by. But if it was in trust, we wouldn't have to do it because the trust does not die with us.
Okay, that's good to know. A trust does not die with us. Ooh, I'm gonna put that in a wrap. I'm sure. Thank you for that rhyming phrase right there. Okay, and my last question is: you mentioned earlier as well. What is a revocable trust?
Well, it just means that the person that creates the trust maker, they are the person that has the authority to change the terms of the trust, as long as they have the mental capacity to change the terms of the trust. So if I, I have my sound mind, and I, decide instead of, giving half of my assets to my former university, and and the other half is going to be split just to my two children, well, maybe my wife did good this year and I want to include her in the trust. And so now I'm going to include my wife and my two children. I have the ability, because it's a revocable living trust, and I can change that.
Gotcha. And even though I said it was my last question, who determines when a person is of sound mind and judgment?
Question. Well, it's going to determine. A lot of situations ask for a doctor, a physician that is treating you, and a neurologist or doctor of the brain that's actually can help treat and determine whether you have the mental capacity. Sometimes in your document, in your trust, you can outline and explain and express what it means to be mentally competent. It can say, I want two physicians, two different physicians. I want two different physicians that are not working for the same entity to be able to work. So you can control some of that as you're writing that trust, to determine what does mental capacity mean, what does mental incapacity mean, and who is to make that decision. You could also say, I want a team of my 3 or 5 people that know me best to be able to help me. They can make a decision about my capacity or incapacity. I can have a trustee panel. But ultimately, the person that creates the document determines who helps make that decision, whether they're getting assistance from physicians or whether they're doing it themselves.
This is amazing. Erick, you are a genius.
No,
okay?
No.
If nobody has told you that
No.
today, go ahead and bask in this for a moment, okay? Because
No.
amazing. I have learned so much. Okay. Well, listen, in this day and age, that's a good word to be called. Take genius. Go ahead, just run with it. You up there with Albert Einstein now? Go ahead, take it. So, thank you again so much. We're actually going to conclude part 1 of our estate planning discussion. But before we go, can you please tell everyone how they can reach you, where they can follow you, what they can do to connect with you if they have questions, concerns, or just want to come to a class? They want information about what's going on in your world. How can they reach you?
So you can go to TyroneLawGroup.com. That's Tyrone, Tyrone, lawgroup.com. You can leave a message with there, on that platform, and it'll go directly to myself and my staff. The office number is 301-358-6664. The email address, Tyrone@TyroneLawGroup.com, and on Instagram and Facebook, and I believe even Twitter, it's essentially the Tyrone Law Group. If you look that up, that's where you can find us. And if I have a slogan, because I do estate planning and personal injury, so it says, if you get hurt and it's not your fault, pick up the phone and call Tyrone.
Okay, I had to throw it in there because it wouldn't be right if you didn't. I'm the realtor, not the salesman, okay? But nonetheless, again, thank you so much, Tyrone. Everyone, please follow my man. I actually said, you got me saying Tyrone now. Please follow my man, Erick. He's giving you his information. We will be back again for another episode of Real Talk and Real Estate with your girl, Kim McBride, also known as Get Keys with Kim. Have a great